certified elder law attorney, and Don became famous for having had two very important cases at the New Jersey Supreme Court and established really crucial principles for the elder law community. And Don's going to be talking to you more on the subject of the residents' rights and how to deal with threatened discharges by the facilities.
Thanks, Linda. Good afternoon, everyone. Let's see. Let's see what's happening here. Okay. So this is what I'm going to talk about. Discharges from facilities, okay, based upon the stated inability to meet the residents' needs. So I have the PowerPoint is in your material, page 113. If you want to follow along. And yeah, again, I wrote a paper. It's got all the citations to it because it's all federal law. But you know, I didn't cite it in PowerPoint, of course. But there's, you know, there's a lot of CFR citations and USC citations, and they're all in the paper. The paper's on page 99. Okay. So when you talk about this area, nursing home discharges, you have to start off with the Nursing Home Reform Act and all the amendments there too. The first one was passed in 1987. It was an effort to reform the problems that existed at that time: widespread abuse, neglect, inadequate care, denial of basic rights. And important for our purposes, it provides a criteria for the involuntary discharge or transfer of a resident. And here it is. A skilled nursing facility must permit each resident to remain in the facility, and you can't transfer or discharge a resident unless, and there's a number of exceptions to that. The first one is the transfer or discharge is necessary to meet the resident's welfare, and the resident's welfare cannot be met in that facility. So this is the section that many nursing homes use to support their transfers, and it's what we're going to focus on today. But there are other sections. And there they are. Okay. The other sections, the resident's health has improved, so it doesn't need facility care. The safety of other individuals in the facility are endangered. The health of other individuals would be endangered. The favored one, one of the favored ones, the resident has failed to pay. You know, problems with getting payment through Medicaid, or they're not passing through the income to the facility. You hear that a lot as a basis for discharge, or the facility ceases to operate, which I've never seen come up. Okay, so despite the reform, the complaints regarding nursing home discharges rose quite a bit, about 60% in 16 years from the time the initial Nursing Home Reform Act took effect. And the evictions were almost entirely focused on Medicaid beneficiaries. Surprise, surprise, right? Rather than private pay or short-term rehab residents. Justice and Aging, you may know them, an advocacy group, reports that some facilities follow a business model that emphasizes bringing in residents for Medicare payment, but when the Medicare payment ends, pushing the residents out in order to avoid the Medicaid payment. You get paid less on Medicaid. Okay. So there were revised regulations that were passed in 2016, and they were the first major revisions to the Nursing Home Reform Act in 25 years. They apply to all facilities that get Medicare or Medicaid. and they have a slightly different language than the first one. Than the first act. In this one, you can't transfer or discharge a resident from the facility unless the transfer or discharge is necessary for the resident's welfare and the resident's needs cannot be met in the facility. So we're focused on the language because they use this language, this provision to justify evicting residents who are difficult or require more care than usual. And then they have the other provisions too, similar to what I read before. The health of the individual in the facility would be endangered if the resident wasn't transferred or discharged. The resident failed to pay. The facility ceases to operate. The discharge for inability to meet the resident's needs. You have the big thing is all the documentation you're supposed to have. Often you don't have it, but you're supposed to have the basis for the transfer. You have to identify the specific resident's needs that can't be met in the facility. You have to document the facility's attempts to meet the resident's needs and the service available at the facility to which they're going to be transferred to meet the needs. So it's really a very detailed report you're supposed to give in order to justify a transfer on this basis. Also, the resident's physician has to identify the specific needs that the resident is not getting from the facility, and what the facility has tried to do to meet those needs, and how the other facility, the one they're going to be transferred to, is going to be able to do it. The whole idea was the documentation requirement was designed so you could reduce the number of baseless needs can't be met evictions. Too many facilities. I mean, this I thought was interesting. This citation. Facilities are less likely to take action if forced to specify the supposed inability to provide required care and the ability of another facility to provide the care. That was the idea, at least. But I think Linda mentioned this. I mean, there's too many. I mean, I've been in this area for a long time. There's not that many people that fight these evictions. Consumers are unfamiliar with the laws. They are unwilling to complain. They're afraid of retaliation against their loved ones if they do appeal or fight these proposed evictions. And sometimes there's no family or not sufficient family. The resident is too ill to actually assert their own rights.